So let's go live to L.A. now, bring in Brian Claypool, the criminal defense attorney, for his analysis on this. You're in California, so we could talk about that state. But I'd like to start more broadly, Brian, on I think the big question here is how does the Supreme Court go about this? In other words, does it rule in a wide-ranging ruling that basically decides it once and for all the states, or have a narrow focus, say, on Colorado? Because then, other states we could end up dragging this out throughout the year. How do you think they approach it?
Hey, Connell, Happy New Year.
You too.
Yeah, I think the U.S. Supreme Court is going to rule in unison. In other words, the same reason was used by the Colorado Supreme Court that's being used by Shanna Bellows, that arguably former President Trump incited an insurrection through his incendiary rhetoric. So you have the same theory for both states saying we want to take him off the primary ballot. So if the U.S. Supreme Court rules in Colorado, my opinion would be that would set a precedent then and bind over Maine and other states that follow.
All right, let's talk about the law here. We have the 14th Amendment, Section 3 up there, and the case about whether or not the president engaged in insurrection is really at issue here in Maine. It's one person, the Secretary of State, who made that decision. You mentioned her name, Shanna Bellows. Here she is talking about that. Her rationale for, an unprecedented move goes like this. Let's listen.
I'm mindful that no Secretary of State has ever deprived a candidate of ballot access under Section 3 of the 14th Amendment. This is not a criminal matter, and Section 3 of the 14th Amendment does not require a conviction.
That's the issue, right? Because I've heard Trump supporters and even people who don't particularly like the former president politically come out and say that, well, we disagree with a lot that he's done. We didn't like the way he handled himself on the 6th of January, 2021, but there's been no conviction of the crime, federal crime of insurrection or an uprising against the government. She says it's not required. What's your reading on the law?
Yeah, hey, Connell, look, I can see both arguments on this issue. Shanna Bellows, by the way, she didn't unilaterally make this decision. There was a bipartisan committee in Maine that came up with the finding. And there were two former Republican state senators on that bipartisan committee. So she was following their lead. She then had an administrative hearing. So it wasn't done just her waking up in the morning and saying this. There was an administrative hearing. And look, she finds that based on the administrative hearing, that President Trump should be removed from the ballot. We talked why, because his incendiary language incited an insurrection. But I don't think it requires a conviction. I think the other argument, Connell, that President Trump's going to make is, and his strongest argument is, I was never charged with this crime. True, the DOJ investigated this and never even charged him with inciting an insurrection. They had a chance to do so. And that his lawyer is going to argue to the contrary, that, look, there's lack of due process, and you can't take me off a ballot if I've never even been charged with this crime.
Would the timing or would the outcome of this change at all, do you think, if Trump was convicted before the election, say, on the crimes that he is charged with by the special counsel Jack Smith? They're conspiracy crimes. It's not specifically, to your point, insurrection, but would that have any bearing on this, do you think, in the way that the courts look at it?
Yeah, that's a great point, Connell. I think it would. Why? Because what we're seeing now is really a lack of a trial, right? We didn't have a courtroom. Yeah. We didn't have jurors. We didn't have evidence put on by former President Trump. But if there had been a trial, evidence had put on, a jury had convicted President Trump, for example, for the RICO allegation or charges in Georgia, then I think that would be persuasive to the U.S. Supreme Court. Why? Because a reasonable person could then believe that if a jury's convicted former President Trump, that he has arguably engaged in an insurrection on January 6th. It's like a precedent that the U.S. Supreme Court would then be able to rely on.
Now, what about your state? You're out in California. It was interesting. I mean, everybody knows that's a Democratic state, so there's not there's a lot of people politically, again, who probably aren't fans of the former president, but he's on the ballot there. What did you make of that ruling?
Yeah, I did some deep diving this morning, and I believe the Secretary of State or one of the politicians in Sacramento, she made a very insightful remark. She said, "Look, people might differ on this opinion, and I believe that is the case, Connell, even with Shenna Bellows in Maine. Reasonable minds differ on this, but at the end of the day, what she said was, this involves really complex interpretations of the 14th Amendment. It's never been used before in this context." And she basically said, and I think it's a reasonable conclusion, that we need to leave this up to the U.S. Supreme Court to interpret this complex legal issue. And by the way, Connell, Shenna Bellows said the same thing. She was very thoughtful. She's like, look, here's my ruling, but I defer to the U.S. Supreme Court. I invite them to come in and make a decision. And guess what? If their decision is adverse to mine, we're going to honor that decision.
Yeah, it's almost definitely where this is headed. And to the first point that we made in the start of the conversation, that if the ruling is wide enough that it impacts all the states, I think that would be the hope, so that the primary process can go on with or without Trump on these ballots. But Brian, thanks for your analysis as always. Happy New Year. Brian Claypool, thank you.
Same to you.
All right.